Hello, everybody. Welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And if you're going through a foreclosure yourself or you need some advice, help, or assistance, you can always email me at foreclosurehelp777@gmail.com. It's spelled just like that with the number 4. So you can send me an email if you have a question about something, and I will be happy to help you. So today we're going to talk about something a lot of people end up talking about, and that's bankruptcy. So let's get started. Okay, so before we get into this week's presentation, we're going to talk about bankruptcy, chapter 13, foreclosure defense, using the automatic stay to save your home. But let's go over the verse of the day, because God helps us with our foreclosures, so we need to give him all the praise and help and everything that we need to give him all. So he'll help us. So the verse of the day is Proverbs 22:3, which says, "The prudent sees danger and hides himself, but the simple go on and suffer for it." So you can see by this picture, there's a foreclosure auction in that house, and that says, "Warning, pain, loss, regret, wisdom and folly, danger ahead." So what does bankruptcy do to help you keep your house anyway, right? Let's talk about that. Chapter 13 is often the most effective before a foreclosure sale occurs. The prudent homeowner recognizes the danger and acts while options remain available. Waiting until after the sale can dramatically reduce the available remedies. So if you have already lost your house to a sale, you don't want to do Chapter 13 because it won't work. It's that automatic stay that kicks in. So if you haven't had a sale happen yet, that's when you need to look at this. And if all your other options are finished, this is what you do. So let's talk about step 1. And I am not an attorney and I don't give legal advice, but this is what the internet world tells you how to do it. So it looks pretty accurate to me. Step 1 is credit counseling. Before filing, the debtor must complete an approved credit counseling course, usually online. Certificate must be filled with the petition. Without it, the case can be dismissed. The important thing is that the provider must be approved by the U.S. Trustee Program. The official list of approved providers is maintained by the Department of Justice. Official DOJ U.S. Trustee approves provider list. So you can find it online. Okay? Most typical cost? Most approved providers charge somewhere between $10 and $50. Many of the commonly used online courses cost around $19 to $25 per household. How long does it take? Usually 60 to 90 minutes. Online, phone, or sometimes in person, a certificate is issued after completion. Certificate is valid for 180 days before filing bankruptcy. So that's something to know as well. So what information do they ask for? Nothing too scary. Usually income, monthly expenses, mortgage payment, vehicle payments, credit card debts, household size. The counselor reviews finances and discusses alternatives to bankruptcy before issuing the certificate. What if the person has no money? Many approved providers offer fee waivers or reduced fees if the household income is low. If income is below a certain poverty-based threshold, the course may be free. Chapter 13, however, is based on income, so you must be a wage earner even to be qualified. Okay, so let's say it is Thursday and the foreclosure sale is Monday. A typical emergency timeline would be Thursday evening, complete the online credit counseling course. Receive the certificate immediately or within hours. Prepare the Chapter 13 petition. File it on Friday. The automatic stay stops Monday's foreclosure sale. The next thing worth learning is the difference between credit counseling certificate, which is required before filing. Debtor education course is required after filing. Skeleton emergency Chapter 13 filing and a full Chapter 13 filing. You need to learn the differences between these things. Step 2, gather information. The debtor needs the last 6 months of income, last 2 years of tax returns, mortgage statements, car loan statements, credit card debts, medical bills, property values, bank account balances, retirement account balances. Everything must be disclosed. Step 3, prepare the petition package. The filing package is substantial. Major forms include voluntary petition, which is the official Form 101, Schedules A, B through J, Statement of Financial Affairs, a means test forms, Chapter 13 plan, creditor matrix. The schedules are where most mistakes occur, guys. Voluntary petition. This is the first form, the official 101 form. This is the document that actually starts a bankruptcy case. It contains the debtor's name, the address, the county, the employer, prior bankruptcies, type of bankruptcy, like Chapter 13 or 7. Whether counseling was completed, signatures. When this form is filed, the case exists. The automatic stay generally begins immediately. This form is usually only a few pages long. Now, Schedule AB assets. This is where the debtor lists everything they own. Examples: real estate, home, vacant land, timeshares, personal property such as cars, boats, jewelry, furniture, guns, tools, computers, cell phones. Financial assets, bank accounts, retirement accounts, stocks, and tax refunds owed. Legal claims. This surprises many people. If somebody has a personal injury claim, an FDCPA lawsuit, or a RESPA lawsuit, or a wrongful foreclosure claim, those may need to be listed. A debtor who hides an asset can get into serious trouble. So, don't hide anything. Schedule C, exemptions. This is where the debtor claims property protected by law. Examples: homestead exemption, vehicle exemption, household goods exception. The exemption laws vary by state. Florida's homestead exemption is famously strong. A property exempted asset generally cannot be liquidated. Schedule D, secured creditors. These are debts attached to collateral. So, some examples would be a mortgage, a car loan, or a boat loan. This schedule asks, who is the creditor, how much is owed? What property secures it? This is where foreclosure defendants often start comparing what they believe is owed versus what the servicer claims. Schedule EF, unsecured creditors. E equals priority debts. Examples: certain taxes, child support, alimony. F equals general unsecured debts. Examples: credit cards, medical bills, personal loans. Many debtors have dozens of creditors here. Number 6, Schedule G, executory contracts. These are ongoing agreements such as apartment lease, vehicle lease, equipment lease. Not everyone has everything here. Number 7, Schedule H, co-debtors. Anyone else liable on the debt is mentioned here. Examples: a co-signer or a joint borrower. Number 8, Schedule I, income. This is one of the most important schedules. The debtor lists wages, Social Security, pension, disability, rental income, contributions from family members. Trustees scrutinize this carefully. Schedule J, expenses. This is where the debtor lists monthly expenses. Examples: mortgage, utilities, food, gas, insurance, medical expenses. The trustee compares Schedule I and J. If the numbers don't make sense, questions will follow. Number 10, Statement of Financial Affairs. This is the tell us what happened recently form. Questions include income history, how much was earned this year, last year, or the year before. Lawsuits is here. Any litigation, property transfers, did you transfer property recently? Foreclosures, any repossessions, bank accounts, closed accounts, businesses, any ownership interest. This form catches many mistakes. Number 11, a means test. This determines whether the debtor qualifies under Chapter 13 rules. The form compares your household income and the state median income. The calculations can get complicated, and many self-represented debtors struggle here. Number 12, creditor matrix. This is simply a mailing list. Every creditor must be listed with an address. The court uses it to send notices. If a creditor isn't listed, problems can arise later. Chapter 13 plan. This is the heart of the case. The debtor tells the court how much will be paid each month. For example, $750 a month for 60 months. What happens to the mortgage arrears? For example, mortgage arrears, $18,000. Paid through plan over 60 months. What happens to car loans? What happens to taxes? What happens to unsecured creditors? The trustee and creditors review the plan. Why mortgage cases get interesting. The mortgage creditor usually files a proof of claim. This includes the note, the mortgage, payment history, and arrears calculation. For example, mortgage arrears claimed at $42,000. Debtor's records show $28,000. Or the servicer claims ownership but attaches no assignment, or fees appear that were never disclosed. That's why Chapter 13 can become a powerful discovery tool in foreclosure situations, where pro se filers most often make mistakes. Forgetting assets like lawsuits, tax refunds, bank accounts. Undervalued property. Leaving creditors off the matrix. Inconsistent income figures. Failing to disclose transfers. Proposing a plan that they can't really afford. Ignoring trustees' document requests. Missing deadlines to file schedules after a skeleton petition. Many Chapter 13 cases are not dismissed because the debtor is dishonest. They're dismissed because the paperwork is incomplete or the proposed plan is not feasible. For someone facing foreclosure, the forms you would probably spend the most time reviewing are your Schedule D, the mortgage debt, Schedule I, income, Schedule J, expenses, the Chapter 13 plan, and the mortgage creditor's proof of claim. Those 5 documents usually tell the story of whether the homeowner has a realistic path to saving the property. Step 4, file the case. Once filed, the automatic stay begins. 11 U.S.C. 362 immediately stops any foreclosures, garnishments, repossessions, collection lawsuits, collection calls. Everything stops. There are exceptions, but this is the general rule. Step 5, trustee assignment. A Chapter 13 trustee is assigned. The trustee reviews the finances, reviews the plan, requests documents, conducts the creditor's meeting. And then step 6 is the 341 meeting, also called the meeting of creditors. Most are brief. The trustee verifies identity, income, assets, and debts. Questions are usually straightforward. For example, did you review your petition? Is it accurate? Have you listed all your assets? Have you listed all your creditors? Step 7 is the confirmation hearing. The judge determines whether the plan complies with the bankruptcy code. If it's approved, the plan is confirmed. Then the debtor continues making payments. And how this helps in foreclosure cases? Example, mortgage payment is $1,500. Arrears is $18,000. A Chapter 13 may allow regular payment continues, arrears spread over 60 months. So $18,000 divided by 60 equals $300 a month. So the debtor pays the mortgage $1,500 and the plan payment for arrears $300. So instead of coming up with $18,000 immediately, mortgage services must file. When a mortgage creditor participates in Chapter 13, you'll often see proof of claim and a note, mortgage or assignments, payment history, escrow analysis. This is where many foreclosure defense issues surface. You may recognize some of the same problems we've seen: missing assignments, incorrect balances, unexplained fees, arrearage discrepancies, servicer transfers. Terms you should learn, like petition, starts the bankruptcy case, schedules, lists assets, debts, income, expenses, trustee. So these are just terms that you guys need to know. Automatic stay, confirmation. I think most of y'all know these. So for someone facing foreclosure, the timeline is often the foreclosure is filed. The sale is approaching. Chapter 13 is filed. The automatic stay stops the sale. Mortgage arrears paid through plan, and debtor catches up over time. So what Chapter 13 cannot do, usually cannot undo a completed foreclosure sale, does not eliminate all your debts, does not guarantee a loan modification, and it requires regular payments. When Chapter 13 may not be the answer, if you don't have any income, the foreclosure sale already completed, property already transferred, unaffordable plan payment, sometimes another strategy is needed. Chapter 13 is a powerful tool when used early. The earlier a homeowner evaluates options, the more choices remain available. Okay, guys, I hope this information has been interesting to some of y'all that are maybe weighing the possibility of going this route. I know a lot of people do go this route to stop a sale in a non-judicial state. And if you have any questions or comments, you can leave them in the section below. And as always, everyone have a blessed day.